as far as those witnesses are concerned, no, we have not made any specific, and I'm told that the investigators should appear any time between now and, say, the next 45 to an hour with potential witnesses and information concerning that. But as far as those witnesses are concerned, no, we have not made any specific plans, as it were. Well, we do have plans, but of course nothing materialized as far as that.
Is it your intention to testify?
I'm willing, I am considering that matter very seriously, of course.
This is the moment of truth.
Right. It's a matter where I must look at my testimony in the broader context of my strategy and my defense. It is not a matter of just saying, well, let me fill in the blanks. It is not as simple as that. I will just say at this point that I need to look at it. If there is a particular period of time that I need to present myself in a witness stand for any reason, I believe it would be appropriate to at least have my defense in place. From that point, I can take a closer look at the progress of that particular defense and determine need. As you well know, in most criminal cases, especially in murder cases, the defense, the accused simply does not take the stand. I am saying that I could well be that exception. There's no no set rule on that. And as far as that is concerned, that decision will be made based on a number of variables. And these are what I'm looking at.
It's my recollection that yesterday I indicated to you that if you were to testify, today would be the day you would testify.
Absolutely. I recall that conversation. However, this is not, as I indicated, a fill in the blanks. For instance, at the time that I responded to your particular question or suggestion, it may have been in the context of an expectation that perhaps I would have had a witness prior to my testimony. Of course, now that's not the case. If I do take a stand today, there will be no one testifying before me. This creates a number of problems, and especially since I have not had an opportunity to even meet with these particular individuals or that person that the investigator would probably be here with today. Before I even enter into consideration as to my testimony today, I would need to at least get an understanding of this person's perspective and what they have to offer. That way it would be a matter of putting everything in place. But just before I sit down and receive your response, which I know you'll respond to, you mentioned that I had time to have a conversation or so with the Village Voice and a number of others. These are simple telephone conversations for myself during recreation time. I don't believe I can just stick to paperwork all day. And the record will show that I made a single phone call of about a frame on the phone, which is 10 minutes, will automatically cut off on the phone that I have in my cell after about a frame of 12 minutes, whether direct or collect. And I believe the record will show that I had one or so conversation with the Village Voice lasting about 8 or 9 minutes. And I believe for the Associated Press, usually it's about 5 or 6 minutes of conversation, and that is it. I don't believe that would get in the way of any kind of progress with my paperwork.
Will you be ready to proceed at 2 o'clock this afternoon?
As far as witnesses?
Either with witnesses or testifying yourself.
Well, you're asking me to make a very difficult decision, I believe, at this point.
Yes, I am.
Simply because 2 o'clock is sometime later today. And of course...
it's the court's intention to have summations tomorrow. And I don't want to put you in a position where if you're going to testify, you're going to have to testify and sum up on the same day. And it is the court's intention, likewise, to charge tomorrow. As I indicated to you yesterday, that's why I wanted these things accomplished yesterday and today.
I understand that the court is putting a tremendous amount of burden on me to complete a number of things within a given period of time, which is humanly impossible.
Then is put on any lawyer in a case of this length. It is one of the dangers that I warned you of when you decided you wanted to go pro se, that you're going to be under pressure.
Judge, the pressure is not the problem. The pressure I can deal with, and I believe I've done an excellent job dealing with the pressure. It's a matter of what is realistic in the context of my constitutional right to defend myself. It is a simple argument to that. If, in fact, a defendant is not able to defend himself by virtue of restriction placed on him by the court, then he simply does not have a constitutional right to defend himself. And therefore, it is reversible error, I believe, in every regard and at every level of a court to even allow the person to go pro se. It is an impossible task that is being given into the hand of the accused if, in fact, he cannot even get a simple day to perform the fundamental duties and obligations of preparing his case.
I don't want to bring up all of yesterday's discussions about how many days you have had to prepare. But that has been fully discussed, I think, on the record.
If I could continue without interrupting you, Judge, then it comes down to a matter of what is the most practical way, the most realistic way to deal with this? Is it to simply say, use as much of the day as possible?
These dudes out here ain't fighting no more. You either dump or run or go to the law. Me, I take it further, son, this murder one. Maneuver with Rugers like Colin Ferguson. You force my hand to take you off the earth with guns. Justify homicide, that bird is done. I drink that red rum straight out the faucet, your boy lost it. I'm on a Bell Parkway, the ratchet I toss quick. I'm a boss bitch from that beast New York, where that cheap talk get you outlined the chalk. Yo, these dudes out here ain't fighting no more. You either dump or run or go to the law. Me, I take it further, son, this murder one. Maneuver with Rugers like Colin Ferguson. You force my hand to take you off the earth with guns. Justify homicide, that bird is done. I drink that red rum straight out the faucet, your boy lost it. I'm on a Bell Parkway, the ratchet I toss quick. I'm a boss bitch from that beast New York, where that cheap talk get you outlined the chalk. Yo, these dudes out here ain't fighting no more. You either dump or run or go to the law. Me, I take it further, son, this murder one. Maneuver with Rugers like Colin Ferguson. You force my hand to take you off the earth with guns. Justify homicide, that bird is done. I drink that red rum straight out the faucet, your boy lost it. I'm on a Bell Parkway, the ratchet I toss quick. I'm a boss bitch from that beast New York, where that cheap talk get you outlined the chalk. Yo, these dudes out here ain't fighting no more. You either dump or run or go to the law. Me, I take it further, son.
Okay, for the record, this is number 93, Colin Ferguson. Sir, are you Colin Ferguson?
Yes, I am.
Gentlemen, this matter was put on for a felony exam today. Are there any applications at this time?
Yes, Your Honor. Your Honor, I request a 7:30 examination.
Before ordering that kind of an examination, counsel, are you inferring that at this point in time you do not feel that Mr. Ferguson is competent to assist you in defending him in this case?
That is correct, Your Honor.
All right. Mr. Ferguson, do you understand what he's saying?
Yes, and I have something to say for the record.
I'm sorry?
Is it possible for me to say something for the record?
I would advise you to speak to your attorney before you say anything for the record.
I know.
Okay? Go ahead. Speak to Mr. Falanga first.
The matter of my asking you to step down.
Judge, may I approach?
With these mics?
No, they'll be up here.
All right. Step up.
Your
Mr.
Honor,
Barker, you want to approach? Okay, we're back on.
Your
the air.
Honor, I believe that under the present state of the law, as I know it, on these matters, unless you have an affirmative waiver from the defendant, all matters must be on the record.
Well, I don't happen to agree with you. There could be bench conferences at almost any time, but if you don't wish to proceed with the bench conference, that's fine with me.
Judge, I have no problem having a bench conference with the reporter present.
Fine.
Let's go in the back. Have a seat, Mr. Ferguson. Back on the record. Mr. Falanga, do you have any problem, based upon what Mr. Ferguson has told you, with allowing Mr. Ferguson to address the court? Vis-a-vis the facts of the case, that is my only concern.
Yes, I do, Judge.
But he still wishes to address the court.
Yes.
In that case, I'll listen to him. What do you have to say, Mr. Ferguson?
I'm asking that the court relieve Mr. Falanga of representation of me in my case.
You'll have to speak up, Mr. Ferguson.
I'm asking that Mr.
Lean a little bit that way because of the partition. I don't know, that's not a mic that just will strengthen his voice, that's just for the TV.
I'm asking that the court relieves Mr. Falanga of representation of me in my case, and that Mr. Colin Moore be designated my attorney in this case.
Are you going to retain Mr. Moore?
He had agreed to take my case free of cost.
How did that come about?
He paid me a visit recently,
At the jail?
yes, and agreed to do it pro bono.
Mr. Moore, step up.
Good morning, Your Honor.
Morning.
Yeah,
Could you-
Colin Moore, 16 4th Street, Brooklyn, New York.
Mr. Moore, Mr. Ferguson has stated that you paid him a visit at the jail.
That's correct.
In what persona did you pay him a visit at the jail?
Right. After these events, Your Honor, I was approached by certain community leaders in the community who had expressed some concerns about Mr. Ferguson and so forth. So I paid him a visit to basically discuss general things about what he needed and expressed to him what the community leaders, particularly from the Jamaican and other communities, had expressed. And at that point in time, he indicated to me that he wished that I represent him. At that time, he indicated to me that he did not have the necessary funds to retain my services. And I indicated to him that that was not an immediate concern. I would be prepared to represent him without a fee.
It is obvious, Mr. Moore, that this can be quite a lengthy proceeding, and you're willing to take this on without fee. I'm not assigning you.
No, I understand. Yes, Your Honor.
I have some question of how you ended up at the jail and under what, as I use the word persona because I couldn't come up with a better term, you ended up speaking to Mr. Ferguson. You didn't come in as a friend or as a relative, did you, sir?
I came in as, well, I indicated I went there as a friend. Obviously, I was not the attorney. I, however, had to show the authorities at the jail certain identification, and one of the identification I showed them was my attorney card, which I carry with me all the time, virtually, as a means of identification.
You spoke to me by phone, I guess it was yesterday afternoon, approximately 5 o'clock, and I recall asking you something to the effect of, then you were not his attorney at this time.
That is correct.
And you answered, yes, that you were not his attorney
That is
at this
correct.
time.
That's correct. I am not his
Meaning
attorney.
that, well, I guess I thought that meant had he asked you or retained you to be his attorney when we spoke as of 5 o'clock yesterday afternoon.
The reason why I said that, because I was aware of the fact that there was a court-appointed attorney.
Yes.
So, for all practical purposes, I was not his attorney.
Then why, when you signed in at the jail on December 10th, did you state you had been appointed by the court?
I had never stated that, Judge, that I had been appointed by the court.
Sheriff's records seem to be in opposite to what you've said.
If could
But I
just-
will not get into that at this point in time. That may be another issue at another time. I am more concerned of whether you can represent Mr. Ferguson based upon any comments you have made previously to the press, because I believe I saw you interviewed either on television or read it somewhere concerning him. Do you feel that anything you may have commented on this case prior to reaching this point in time would prevent you from representing Mr. Ferguson?
No, Your Honor.
I have another problem. And that problem is Mr. Falanga, prior to Mr. Ferguson speaking to the court, has indicated that he wished the court to order a 7:30 examination and to allow a man who, at least from one attorney's point of view, should be examined by a psychiatrist before anything proceeds, to tell me that he wishes to change counsel causes me certain logic problems, certain conflict here. How can I allow him to retain you, whether without fee or with fee, when there is an attorney, the only one who has really spoken to him in confidence, perhaps except for you? I think you visited him at the jail now twice. To determine that he is, I would have to say that he's now competent to ask me to relieve one attorney and to allow him to retain another attorney. Would you like to address that issue? Or would you rather have me just proceed the way I'm going? Why don't I just continue?
Sure.
Is there anything, Mr. Peck, based upon the investigation of this case, and I don't mean the actual homicides themselves, that you would have knowledge of that you wish to impart to the court since about Mr. Moore, or anything about Mr. Moore and Mr. Ferguson at this time? That would affect representation. That is my only concern.
Mr. Moore's name did come up in the investigation, Your Honor. Whether or not it would affect representation depends upon a lot of factors, including the strategy of the defense. Therefore, at this particular time, I respectfully ask the court not to ask me to give an account of how it may or it may not affect representation.
All right. That would be up to you if Mr. Moore ends up as the attorney in any application you wish to make to the trial judge or to myself before that time.
That's correct.
Mr. Ferguson, based upon Mr. Falanga's request, Mr. Falanga, are you still maintaining that request?
I am, Your Honor.
I am going to, at this time, deny your request for a period of time, and I'm going to order a 7:30 examination pursuant to the criminal procedure law. I will make the return date of that examination January 4th. It will be done prior to that date, and if the defendant is found competent to proceed, Mr. Moore, then I would have no problem at that point in time, unless something else comes in here or comes to my attention from Mr. Peck, Mr. Falanga, or yourself. I would then honor Mr. Ferguson's request to have Mr. Falanga relieved, and that he is retaining you, whether by funds or otherwise. Okay? Mr. Ferguson, do you understand what I'm saying?
Yes, but could I add something?
Go ahead, sir.
I do not anticipate any
Judge, can I-
time
can
in
I-
the
can I-
future.
Wait
Can I-
one second.
Can I
Wait one
find out
second.
what he wants to say before
Yes,
he addresses
go
the
ahead.
court, if I may?
Go ahead, Mr. Falanga.
Tell me first before. I don't anticipate any.
moment to confer with Mr. Moore.
Sure.
Thank you.
You want to step a little further back from anything that might pick you up?
Judge,
Yes, counsel.
if I may, my client has asked me to tell the court that he has no intention of cooperating with me in the future. He thinks the court should be aware of that. I, in turn, have told Mr. Ferguson that my cooperation with regard to the 730-30 exam is of no relevance, except to the extent that I want this court to know, as I previously indicated, I intend to submit an order so that a mental health expert on behalf of the defendant can be present to observe the psychiatric examination. Your Honor has indicated to me that you expect to sign such order, and that
Pursuant to 73020, I think it's the end of paragraph 1, that would be appropriate. It's
Right.
not done that commonly, but it's appropriate pursuant
That
to statute.
that appropriate fees be awarded for this mental expert to participate in such examination. Further, the defendant has asked me to impart to the court that he's being denied his basic necessities.
Let's go one step at a time.
Yes, Your Honor.
Mr. Ferguson, as far as your cooperation with Mr. Falanga, I would urge you to cooperate with him. However, the order that I would be signing would not require your cooperation with Mr. Falanga at all. Understand me? Okay. Now, continue, Mr. Falanga.
He has further asked that I pay him no future visits at the jail. He's also asked that I advise this court that he's been denied certain basic necessities such as soap, that he's being abused at the jail by COs, and further he indicates...
Corrections officers.
Yes. And further, Judge, that he was bought certain items by Mr. Moore, personal items. I believe they may have been clothing, anti-perspirant, things of that nature, and although they were brought to the jail, I think yesterday, that he was not given these items as of yet. I want the court and the record to further indicate that before I imparted all of this information to Your Honor, I conferred with Mr. Moore, who's quasi-involved in this matter at this point, and he concurred that it was appropriate for me to indicate all of the aforementioned to Your Honor.
Mr. Moore, you did indicate to me yesterday that you had brought him certain personal items, clothing items. The court will contact the sheriff on the issues that have been raised and ask that anything that has happened not happen again. Mr. Ferguson wishes to speak to you, Mr. Falanga.
There was a mailbox
Mr. Ferguson would also like this court to be advised of the fact that he has been attacked by way of a milk box, a fire extinguisher, and I think these attacks allegedly took place at approximately 3 a.m., and that his light is left on 24 hours a day, thereby diminishing his ability to sleep. Those are the additional items that Mr. Ferguson asked me to impart to the court, and I have done so, Judge, with the consent of Mr. Moore, again, who is quasi-involved in this matter at this time.
As far as the necessities in his treatment, it's obvious that the sheriff is going to be on notice of this based upon this proceeding, but I will call the sheriff. As far as any attack on Mr. Ferguson in the jail, Mr. Peck, that becomes the prosecution's end. And I would ask the
well,
district
obviously,
attorney's office to
yes.
investigate.
Obviously, Judge, that is our duty, and we will do it. It's a little bit frustrated now by Mr. Moore's statement that he's not going to discuss this anymore with Mr. Ferguson.
First names, I believe.
Yes,
you're saying.
Mr. Ferguson's statement that he's not going to discuss this anymore with Mr. Falanga. But yes, we will take whatever steps necessary.
Mr. Ferguson, you understand if there were to be any criminal charges brought, you'd have to speak to the prosecutor and any investigating detective. Do you understand what I'm saying? Okay.
Judge,
So if that's what you choose to do, when they choose to send someone to speak to you, it is obvious they would be speaking to you only about the complaint that you are filing, not about any of the facts of the case that has brought you before the court.
And, Your Honor, we can do that before or after the return of the 7:30 examination.
I would suggest it is after, but my call will be made before.
Your Honor, while we are addressing these type of issues very briefly, I believe I previously indicated to you some difficulty and frustration in being able to interview Mr. Ferguson during my visits at the correctional center.
I have spoken to the sheriff's office, and that I know there is added security that has been used in dealing with Mr. Ferguson, and I have asked the sheriff to make sure that Mr. Ferguson and his lawyer are not treated any different, whoever that lawyer is not treated any differently than any other defendant who is trying to confer with counsel. So whatever room or rooms that should be made available to a normal attorney-client attempting to prepare for trial or hearing, they will be made available to either you or perhaps in the future Mr. Moore in dealing with Mr. Ferguson and speaking to him at the jail.
I want the court to be aware of the fact that notwithstanding Mr. Ferguson's request that I pay him no further visits based on my obligation to represent him, I will attempt to continue to do so by paying visits until such time as those trips prove to be of no worthwhile. Finally, Judge, I just want the record to indicate, no matter what the results of the 7:30 exam, I do have reason to believe there may be other impediments to Mr. Moore representing Mr. Ferguson. I want the record to be perfectly clear that I have no problem, and I welcome anybody that Mr. Ferguson would want to represent him. I'm prepared to step aside. However, as I indicated, I do have reason to believe there may be impediments to Mr. Moore's representation, which we can address if and when that issue arises in the future, after January 4th.
Do you mean impediments that would have brought about Mr. Ferguson's requesting Mr. Moore as his attorney?
Among other things, yes, Your Honor.
Well, we'll put that on hold for a little
Yes, Your
while. All right. In that case, the matter is adjourned to January 4th, 1994 for the return of the 7:30 exam. Copies, of course, pursuant to statute, will be sent to Mr. Falanga and Mr. Peck. And if you so choose, Mr. Falanga, you can avail those to Mr. Moore. Obviously, they will be made available in open court, as the results will be made available in open court on January 4th.
Thank you very much, Your Honor.
Anything else, gentlemen?
Hey, could I just request a visit after this with Mr. Ferguson?
In the back now?
In the back.
The only problem that I would have with that is a security issue. It actually have two problems. The only person who can really visit the defendant in the rear is his attorney. You are not his attorney at this time. That may not stop you from visiting him in his jail as his friend or as a friend of the family, but the only one who can visit him in the back is his attorney, and as of this moment, you are not yet his attorney. So that is denied.
Thank you, Judge.
Jimmy, what bus you got? Jimmy, what bus you got? 62. Where are we going to be going? How? Where's he going? Watch your back. Hold on. You can't go to Whitney. Go, you got it. Thank you. Come in. All right, go ahead. Hold on. Tell them where they're going. Okay, where you go? We want to go to Whitney. You got a name here? Mini old volleys here. First bus. 10-4. 10-4. The bus is right down the bottom of the steps. Might be easier to go on, all right? Yeah. Swing them down, swing them around back. All right, go ahead. Waste his time. Wait, please. Go ahead. The bus is right there. Yeah, 10-4, come back here. It's down there, hon. If I say it again, I'm going to help you. ഒരു ഡോർ ഇങ്ങോട്ട് തുറക്കുമ്പോൾ അതിനങ്ങോട്ട് നിൽക്കുന്നതിന് ഒരു ഡോർ തുറന്നപ്പോൾ
See the gun? Over your head, thank you. Raise it higher. Raise it higher, please. Higher.
Jimmy, I have it too.
You got it?
Yeah.
Okay, good, Larry. Thank you.
There's extra tapes that are under there. I left tapes.
Yes. I got switched it.
So the trump card here appears to be racist. Strong hostility is mentioned in the first pieces of paper put down on the suspect. Not only not that but he wrote that somebody else was going to take down the pieces of the suspect. Much like how the law here, which is a lot of reasons. Strong hostility. Black and against Chinese mentioned actually he also mentioned a number of
Sertal.
Semi-automatic?
Don't know that.
What's
Pistol. We haven't tested it to see if it's semi or full. We haven't tested it.
was it worked on at all?
No, it just came from Prince.
No, did he work on it?
We haven't tested it yet in firearms.
Excuse me, would you just do me a favor, go off the stage, please? Watch your step there.
Yes. Barrel toward you? A little lower?
That's like a recent manufacturer, right?
It's not like a...
Fairly what?
I don't know, the trace hasn't been done yet, but the model is not an old model. It's a fairly new model.
Okay. Profile it again.
The way you had it before is fine. Yeah, that's good.
Do you know what kind of slugs did he use?
That's okay. Yeah, I'm just waiting to see what you stretch it out a little bit.
This is the moment to stand together, to speak out together, to embrace each other, to turn to each other and not on each other. Silence is betrayal. Burdens shared are easier to bear. He lashed out angrily at all shades of humanity. He must not be allowed to pull us down into his snare of anger and evil and fear. There is a more excellent way. Today we grapple not so much with black and white, but with wrong and right.
For years, the idea of gun control was off limits in Washington, but tragedies like the Long Island shootings have put it at the top of the agenda.
I hope that this will give some more impetus to the need to act urgently to deal with the unnecessary problems of gun violence in the country.
There are any number of ideas here for doing that. The 15-round clip used by the Long Island gunman would have been illegal under an assault weapon ban now being considered by Congress. It is now the top project for Jim and Sarah Brady.
When the Congress returns in January, they can once again expect to see me wheeling through the halls.
The mayor-elect of New York, meanwhile, has asked President Clinton to support licensing gun owners.
Licensing that would be very similar to the licensing that's required to drive an automobile, which would require showing proficiency in the use of a handgun as well as demonstrate the ability to keep it safe.
Gun groups, however, reject the idea as unconstitutional.
And the Constitution says nothing about automobiles or the right to own and drive automobiles.
And the National Rifle Association says tougher gun laws won't solve the crime problem.
So I think Americans are frustrated with crime, and I think they've recognized that you can't get any crime control from gun control.
The NRA promises to continue the fight against any gun control legislation. But those who favor tougher gun laws believe the tide has turned. Polls show a majority of Americans favor tougher gun laws. The Long Island tragedy perhaps providing unfortunate momentum. Mike McKee at the White House.
our spiritually beautiful, physically beautiful, and artistically talented daughter died of a bullet to the neck, one of the many victims of one gun. One gun. The awareness of the LIRR massacre is now known nationwide. The resulting effects, however, are eternal in scope.
The President of the Long Island Railroad, Mr. Charles Hoppy, our Commissioner of Police, Donald Kane, and our Chief of Detectives, Richard Fierro. I'll now turn it over to County Executive Galata for some comments.
I spent most of last night at the scene and here at police headquarters. I've come away from that tragic event with two emotions. Our hearts go out to the victims of this terrible tragedy and, of course, to their families. At the same time, I think we very clearly recognize that what happened last night was a massacre. The person who committed this crime is an animal who turned that Long Island Railroad car into a death chamber. If you had seen what I saw last night, and I hope you never have to, you too would share the emotion that there is no penalty too severe for someone who would wrought this type of pain and suffering upon the victims of this crime and their families. At the same time, I come away with a second emotion of appreciation for the members of the Nassau County Police Department, the members of the Garden City Police Department, the members of the Long Island Railroad Police, the emergency medical response teams, the doctors, nurses, all who worked in a cooperative effort for a speedy and comprehensive response.
At the funeral service for James Goricki in Mineola, Father Robert Batul preached a message of love, telling the congregation to try to rise above the horror and shock of the shootings and live the virtue of hope. The 51-year-old salesman was one of the first people killed when Colin Ferguson allegedly opened fire on the 533 Long Island Railroad train.
No better than Jim. Honest, thorough, the whole bit. A great, great man, and it's a great loss to more business forms and to the world.
Also paying his respects to Goricki and his family, Nassau County Executive Thomas Galata.
If there's anything to be learned from this process, it's that there's a very clear need in this state for the death penalty. If someone takes the life of another human being, they ought to be prepared to sacrifice their own.
In New Hyde Park, friends and family of Mi Kyung Kim attended a memorial service after the 27-year-old woman was cremated. Kim had been on her way home from her job at Columbia University in Manhattan. In Mineola, a wake for 52-year-old Dennis McCarthy will be held Saturday and Sunday at the Cassidy Funeral Home. He was on the train with his son Kevin. The 26-year-old was critically injured.
One person told me the motives. I don't have the energy to dwell on any of that right now. Kevin right now is my main concern. Starting sometime tomorrow, I've got to start preparing myself for Dennis.
The funeral for Dennis McCarthy is Monday at the same church where friends and family said goodbye to James Goricki. In Mineola, Nicole Nogid, News 12, Long Island.
Exactly 1 month after he allegedly opened fire in a Long Island Railroad car, Colin Ferguson spoke, complaining in a rambling voice to Judge Ira Warshawski about a litany of illnesses he says he's suffering from in prison.
I presently suffer from kidney stones. I've had kidney stones past as large as an inch. Prior to my coming to jail, there was urine in my blood, which a doctor had seen the samples of it prior to my being arrested. Of course, there is no sympathy for me in the institution that I'm presently housed.
In front of a courtroom filled with reporters and court officers, Ferguson reiterated that he has no intention of working with his court-appointed attorney, Anthony Falanga.
Of course, you know, I question Mr. Falanga's integrity. And as far as what he has done so far, I have rejected out of hand and have opposed. I have objected to every single thing that he has done from the onset.
Why do you wish to proceed per se? Just to be a formidable adversary to Mr. Fred?
Absolutely not. I just stated my feelings as far as my inner expectation. But question, and your question, it has nothing to do with that. I believe that I can prove my innocence. I believe that I can be acquitted. And I believe that I can do a better job than just about anyone else. I believe integrity is more important than just raw expertise. Raw expertise without integrity, if that's the proceedings thus far, I believe that an appellate court would have no problem putting aside my inadequacies and look to the bigger instances of injustice toward me.
Do you think you could control your emotions during the trial?
Absolutely.
You're shackled or unshackled. That has nothing to do whether you should be represented by a lawyer or not.
Well, you're saying that...
He's accused of gunning down 6 people aboard a Long Island Railroad train back on December 7th, 1993. 1 year later, it seems Colin Ferguson is not much closer to standing trial for those crimes than he was the day he was arrested at the Maryland Avenue train station. Today, his lawyers are once again trying to prove, apparently without their client's cooperation, that Ferguson is delusional and thus not competent to stand trial. The first witness called by the defense was the Manhattan psychiatrist who briefly examined Ferguson several months ago in the Nassau County Jail. To bolster his argument, Ferguson's attorney at one point read several letters that Ferguson wrote in the last year to Judge Donald Belfi, letters in which Ferguson professes his innocence and claims to be the victim of a conspiracy.
My attorney and all of the above-named parties, attorneys, ADA, court, jail, are therefore attempting to have me go blind to prevent me from identifying the shooter if I am, in fact, able. Is that consistent with delusional disorder?
Yes.
If you think all this sounds familiar, you're right. Ferguson was already found competent to stand trial shortly after his arrest last year. But a second competency hearing was ordered recently because his attorneys maintained that his mental condition severely deteriorated after he was attacked in jail in March. Prosecutors, on the other hand, insist the alleged gunman is now and has always been competent, and they're hoping to begin Ferguson's actual trial sometime in January.
We believe the evidence will show that he is competent to proceed. Competency being that he's able to assist in his own defense, that he understands the nature of the charges against him, and it's a very simple test, so we believe he's certainly competent to stand trial.
The competency hearing continues on Wednesday, though it's not quite clear if Ferguson will be here. At the end of the day on Tuesday, the accused gunman said he was concerned about showing up in the courtroom on the anniversary of the shooting, and he said he wanted security to be increased. In Mineola, Matt Jablow, News 12.
And Mr. Casaza, when you turned around, were people in the process of reacting to those noises in terms of moving for cover?
At that time, I think everybody was stunned and in shock, and as I can remember, nobody was
Judge,
moving.
Can I just object to the speculative part of the
Stand straight to where it's stunned.
To my recollection, nobody was moving. Because when I turned around, all I saw was you standing there over this person who was...
So it is your testimony that at the time you looked around, there was no one moving, and you saw the shooter?
Exactly. Uninterrupted, yes. Few.
And Mr. Casaza, you indicated that the initial sounds you heard were 6 gunfire shots.
For pop-pop noises, maybe half a dozen, yes.
Mr. Casaza, on the day, the 7th day of December 1993, did there come a time, shortly after the incident, that you went to police headquarters?
No, I was never at police headquarters.
Where did you go directly from the scene?
The ambulance took me directly to North Shore University Hospital.
And for an extension of time?
Insofar as the points you just raised, I did see you on Larry King last night. You did not appear to me to be under any force, pressure, threats, or coercion when you had the conversation with Mr. King. I also understand you were in communication with the Associated Press, with Village Voice. Again, if you have the time to do all of these things, I just can't see you coming into court saying you don't have time to prepare your defense or prepare your summation.
Right. It's a matter where I must look at my testimony in the broader context of my strategy and plans, as it were. Well, we do have plans, but of course nothing materialized as far as that.
Is it your intention to testify?
I'm willing, I am considering that matter very seriously, of course.
This is the moment of truth.
Right. It's a matter where I must look at my testimony in the broader context of my strategy and my defense. It is not a matter of just saying, well, let me fill in the blanks. It is not as simple as that. I will just say at this point that I need to look at it. If there is a particular period of time that I need to present myself in a witness stand for any reason, I believe it would be appropriate to at least have my defense in place. From that point, I can take a closer look at the progress of that particular defense and determine need. As you well know, in most criminal cases, especially in murder cases, the defense, the accused simply does not take the stand. I am saying that I could well be that exception. There's no no set rule on that. And as far as that is concerned, that decision will be made based on a number of variables. And these are what I'm looking at.
It's my recollection that yesterday I indicated to you that if you were to testify, today would be the day you would testify.
Absolutely. I recall that conversation. However, this is not, as I indicated, a fill in the blanks. For instance, at the time that I responded to your particular question or suggestion, it may have been in the context of an expectation that perhaps I would have had a witness prior to my testimony. Of course, now that's not the case. If I do take a stand today, there would be no one testifying before me. This creates a number of problems, and especially since I have not had an opportunity to even meet with these particular individuals or that person that the investigator would probably be here with today. Before I even enter into consideration as to my testimony today, I would need to at least get an understanding of this person's perspective and what they have to offer. That way it would be a matter of putting everything in place. But just before I sit down and receive your response, which I know you respond to, you mentioned that I had time to have a conversation or so with the Village Voice and a number of others. These are simple telephone conversations for myself during recreation time. I don't believe I can just stick to paperwork all day.
Efforts to arrive before any conversations were had with the witness and yourself.
Then, Judge, politely I would take exception to that since I am representing myself pro se. I have an absolute right to represent myself. It is a constitutional right under the 6th and 14th Amendment. To bypass me, to circumvent me on these important issues is a clear disregard for my rights to represent myself. And to go directly to my advisors, I believe, is simply a matter which is unacceptable, I think, even to the court.
Your advisors to be here so that they can advise you should you solicit their opinion as to whether or not you wish to put this witness on the stand.
Judge, first of all, just to go back a little bit, I believe you're referring initially to the one appearance this witness made outside of this courtroom, and I believe notes were sent in through one of the court officers. I believe it may have been Sergeant Moore.
and at which time I asked that we be granted a recess that Mr. Rose could go out and speak with this individual. From there on, for some unspecified reason, this witness became separated, at which time I spoke with the court asking that you would personally appeal to the media to publish the fact that we were looking for this witness and asking that witness to come in.
I would point out, which the court did do, and the following day the court's chambers received a call from a woman who identified herself as an attorney for an insurance company, who gave the name of this particular witness and the address, which immediately was turned over to you.
Absolutely, and from that point on, we pursued the matter with great diligence. We used an investigator. It was a matter of locating this witness. We finally, I think, located a witness perhaps a couple of days ago as to his location. From that point, I believe, based on what he said today, he heard media reports that, in fact, Mr. Ferguson needed witnesses early this morning, and he came in response to that. So this is our first opportunity to meet with him physically.
Yes. Are you a doctor also?
Yes.
What kind of doctor are you?
I have a doctorate in psychognosis.
In what?
Psychognosis.
From where?
The same place Hippocrates got it from. It's a spiritual gift. Right.
It's a rare treatment of the psycho-soul.
You're on the third train?
Okay. I have to say this. I have to say this.
We may not be able to be alive to get back here to say this if it's not said now.
Mr. Ferguson is a victim here. He has been set up by the United States government.
What did you see? What did you see on that train?
Yes, what did you see? Okay. I was taken from my car in the Bronx on the day this happened.
December 7th, Tuesday.
Around 4 o'clock. I was driven by 2 white men and an Oriental gentleman, 3 men, in a black 4-door sedan. No, they were CIA agents.
So what did you see on the train?
I was taken to the train by these gentlemen, and I have documented proof. I have other witnesses who have seen these same people. They put me on the train, and I was towards the back of the train, shielded by the 3 gentlemen. The Oriental gentleman says to me, "Look at the black man sitting over there." I look, and he pulls out what looks like a remote control. And he presses a button, and Mr. Ferguson falls asleep.
Go ahead, tell them what happened. My husband has been kidnapped twice in 1994, April 28th and December 15th. I have internal affairs reports, a letter from Janet Reno, and I have documentation from the federal government right here in this package for any of you that think spaceships is any part of this statement. This is factual.
What did you see? Before I hand it out, what did I see? Again, Mr. Ferguson is in this mess because of us. He was used as an example.
This morning, and he came in response to that. So this is our first opportunity to meet with him physically since the first time that he came to the courtroom. This is not a matter within our control. It's now an issue of Mr. Ferguson's defense. I am now saying that I need to take a second look at my defense as regards to this witness. Of course, that will affect my summation. Obviously, if this witness takes the stand, it will affect my summation. It will also have me revisit the whole matter of my testimony, perhaps.
And kills a spectator, it's still murder. Listen to his charge. Count number 2.
And the grand jury of the County of Nassau, by this indictment, further accuses the defendant of the crime of murder in the second degree in violation of Section 125.25, Subdivision 2 of the Penal Law in the state of New York, committed as follows. The defendant, Colin Ferguson, on or about the 7th day of December 1993 in the County of Nassau, state of New York, under circumstances evincing a depraved indifference to human life, recklessly engaged in conduct which created a grave risk of death to another person and thereby caused the death of such person, to wit, at the time and place aforesaid, the defendant, Colin Ferguson, discharged a loaded weapon multiple times within the confines of a Long Island Railroad passenger car containing numerous occupants therein, thereby causing the death of Dennis McCarthy by shooting him with a 9mm pistol. Depraved indifference murder. You don't have the intent to kill a specific person, but your actions are so reckless, so callous, so wanton, and what's more so than firing into a crowd multiple times, it's another theory.
Is prepared to enter in to my defense, right, to testify in my behalf in a limited capacity. As far as the case is concerned, he's a psychiatrist, but it will not be on the matter of competency, nor is it on the matter of an insanity defense. For limited reasons, as you know, that psychiatrists can be used in various ways within the scope of the case.
Is he available to testify right now?
He is not, but he indicated that the court could contact him by phone. And he could come into the court. However, the time that he would need to effectively accumulate data for such testimony could not be done in a day. It would perhaps require 3 or so days. If we were to really narrow it down, he could probably accomplish this in 2 days. But he's simply saying that it would be possible for him to...
What would be the nature of his testimony if it had nothing to do with an insanity defense?
Of a weapon. And that is a charge that could be given to the jury.
Objection sustained. Any legal matters will be handled by the court.
This. And while I'm doing this, I can assure the jury that if in fact the defendant in any way had a criminal record, that would have been brought out by the prosecution. Judge, is there a way you could, is there any way we could have a recess, just a 5-minute recess? We could also just need...
I would prefer that if you finish.
Since there is a presumption of innocence on the part of the defendant, to have a form where the first line is guilty and the wording of it, if you find the defendant guilty of this count, then you must. I would have rather seen a form in which the first line was not guilty, since the burden of proof is on the prosecution. And then the...
I couldn't tell how many were shot. It was almost silent. There was no one standing. There were a few murmurs. I then turned to my right to look for the emergency panel. The door to that panel was already open, and when I looked into it, I couldn't determine if the brake cord was in there or not. I was a little confused. I was afraid that if I made a mistake, I would turn off the lights on the car. Question, as of this particular point, Mr. McDermott, were you, as of this particular point, feeling any debilitative effects of the gunshot wound? Answer, I was conscious and alert, but in pain. Question, proceed. Answer, when I decided not to go to find the emergency cord, I turned my head to my left, and I could observe the elevated concrete platform.
Colin Ferguson, in my almost 21 years as a judge, I have never presided over a trial with a more selfish and self-centered defendant than you. The vicious acts you committed on December 7th, 1993, were the acts of a coward. What could be more cowardly than entering a train filled with unsuspecting, homebound commuters and systematically shooting them at point-blank range? What is even more remarkable is your total lack of remorse. That is patently evident to this court. These atrocious crimes committed by you on December 7th, 1993, emphasize the need for legislative reform with respect to the sentencing parameters for B-violent felonies. This court suggests that the New York State Legislature remedy the situation by changing Section 770.30 of the Penal Law and lifting the 50-year cap applicable to people convicted of 3 or more violent felonies, one of which is a B-violent felony. The contemptible crimes committed by you, Colin Ferguson, illustrate how fundamentally unfair and unjust it is for a person such as you to have to serve only 50 years after trying to kill 19 people and after having been convicted of 19 B felonies. This court respectfully requests the legislature to address this injustice and to remedy the situation by eliminating the 50-year cap. In this particular case, since you killed 6 people, this cap is immaterial, but in other cases it may not be. Recently, the New York State Legislature did act in the fight against crime. The legislature passed, and Governor George Pataki signed into a law a statute that allows for the ultimate sentence for a certain convicted murderers, death. Unfortunately, this law cannot be applied to you, Colin Ferguson, for the crimes you committed inside the 3rd car of the 533 Long Island Railroad train to Maryland Avenue on December 7th, 1993. The court is, however, empowered to mete out a sentence which is the functional equivalent of life without parole. That is what I intend to do, thereby ensuring that you, Colin Ferguson, will never again return to society, but rather will spend the rest of your natural life in prison. Based upon all of the evidence presented to this court, the court will now hand down its sentence. It is ordered and adjudged by this court that for the crimes of murder in the 2nd degree, 6 counts, all Class A2 felonies, under counts 1, 3, 5, 7, 9, and 11, upon a jury verdict finding you guilty under indictment number 86739, that you, Colin Ferguson, are hereby sentenced to an indeterminate term of imprisonment, the maximum of such sentence for each count to be life, and the minimum of such sentence for each count to be 25 years. These 6 sentences are to run consecutively to each other. The court hopes that the victims and the victims' loved ones can find some solace in the sentence the court has just handed down. This concludes the sentence of the court.
Mr. Ferguson, you have the right to appeal the sentencing proceedings. If you wish to do so, you must notify this court within 30 days. Your attorney or your legal advisor is directed to assist you in this call.
That's
One final thing, the letter you wrote requesting isolation will be has been given to the probation department and will accompany you wherever you're sent to.
I have to notice what appeals on the table. I want to serve it to that.
Ms. Hogan,
No, I don't believe he's insane. I really don't. I believe now he realizes that we found him guilty, and he realizes that there's no way he did it. And that was it.
Fred Hecker is one of the reasons Colin Ferguson will be spending the rest of his life in prison. After deliberating nearly 11 hours, Hecker and his fellow jurors sent back a clear verdict. Ferguson guilty of being the Long Island Railroad gunman. In the first televised interview given by a juror after the verdict, Hecker explains why it took so many hours to convict a man who put up such a weak defense.
The deliberation process was very long. It was 11 hours, and the reason it took 11 hours was there were 93 charges, and we actually went through each and every charge. There was not one charge that we did not go through.
But Hecker says there was no doubt among jurors during any part of the deliberations of Ferguson's guilt. While reaching the verdict went smoothly, Hecker admits some of Ferguson's behavior in court was puzzling.
93 counts, only because it matches the year 1993.
That I always wondered about. Why are you saying 93 counts at 93? You know, 28 counts at 28. That didn't faze me in the least. I believe he was a very intelligent person, though he went, he took the wrong turn in life.
Some argued Ferguson went insane. His former attorneys had wanted to press an insanity defense, but Ferguson rejected it and then fired his lawyers, deciding instead to play attorney and defend himself, arguing that an unknown white man was the real shooter. How do you think he performed as his own attorney? Did he score any points on any witnesses?
Unfortunately, I believe because he did his own attorney, as you say, he didn't know the law, and that's what hurt him. At points, he had trouble because he didn't know where to go or what to do.
The verdict came days after top state lawmakers agreed on a framework for the death penalty. Hecker doesn't know if he would have voted for it if Ferguson was eligible for it, but he's comfortable with just knowing Ferguson will never be free again. For Hecker, this was a positive experience. He says jurors plan on holding reunions and that his belief in our judicial system is now stronger than ever. Andrew Schmertz, New York 1.